We will be dealing with industrial action in Europe and what employers need to know now. Now, 5 years ago, there were hardly any strike activities. The economy was booming and strikes were not really an issue. That has changed over the last few months with gas prices, energy prices increasing, and inflation picking up. And we see strike activities organized by unions, employee representatives throughout Europe and including the United Kingdom. That's why we decided and thought it's a good idea to give you an update about what you need to know and what do you need to plan for if industrial action hits you, or if industrial action is something you encounter because of the discussions you have with unions and your employee representatives. Now we have a range of experienced speakers I'd like to introduce to you. There is Max Biolcini, a very experienced partner from the Milan office of Baker McKenzie, who has dealt with many strikes and industrial actions over the past years successfully for our clients. Now, France is a country where historically employees resort to industrial action and strike activities if they are unhappy. And I'm happy we have Eleonore Dantonnet today with us. She will enlighten us about what's happening in France. The Netherlands is a country where before resorting to strike activities, people negotiate a lot, but you need to know what happens if your negotiations don't work out and strike activities are an option the unions want to resort to. So Lotte Osinga, I'm happy you join us today on that panel. Now, many years ago, there was Maggie Thatcher, we all know, and she basically won the battle against the unions. And I personally thought, apart from the tube in London, which from time to time is hit by strikes, there are no strikes in the UK. And Richard Cook told me it is completely different. And I know we are advising a couple of clients today because they are hit by industrial action, and that's not the public sector, but this is, you know, industries, clients we have in various areas of the economy now face industrial action. So happy, Richard, you're with us today. Now, we also thought it is worthwhile to take a look to Eastern Europe, because Eastern Europe has been a booming region over the past decades. But employees have taken a different attitude towards their employers, and there is also strike activities, not as much as we see in France, but this is something you need to know, or you should know, when you advise the business on any risks that derive from industrial action. So Michal Liswa from our Warsaw office will cover that. And finally, Jose Prieto from the Madrid office. He is an expert when it comes to industrial action. And industrial action in Spain is similar as we see it in France. Maybe not as difficult to resolve, but you should know about what happens in Spain and what are the activities you could expect from unions. Maybe we switch to the agenda to give you some more details what will be coming up in the next 60 minutes. So the first question we will deal with is, on what grounds can a union call for industrial action? Then what types of industrial actions are common in the various countries? And we do have procedural requirements, not in all jurisdictions, but in some, where unions cannot just simply start a strike, but there has to be a formal procedure before they go on strike. And then looking at employers, what can employers do? So is it worthwhile to go for an injunction to stop the industrial action or strike activities with the help of the labor court? And then strategic planning ahead of any strike activities we think is key. So what options do we have to keep the business running? And how do you deal with demonstrations, with picketings as an employer? And finally, is there any other way you can sanction employees who take part in industrial action? And are there finally any other effective remedies against unions who call for unlawful action if there is unlawful action that we detect or find out? With that, I'm happy to hand over to Eleanor and Richard to give us an overview of what's currently going on in Europe. So over to you, Eleanor.
Thank you very much, Alexander. So as mentioned by Alexander, the industrial action became really a hot topic in Europe. And in particular in France, where actually it has always been a hot topic. And today, for example, is the first day of a strike of the national train company. We didn't choose the date on purpose, but it just illustrates the fact that strikes are very present in France. We had two main industrial actions at the beginning since September in France, which really impacted the country as a whole. Which one is the Total Energy strike, which impacted the petrol stations. People had to queue for hours to get petrol, pay very expensive fuel, and the strike started in September 27 and ended in the mid of November, although an agreement was found with the trade unions by mid-October. The government had to put pressure on the management of Total Energy to start negotiating, because one of the bases of the claim was notably due to the fact that very high profits of the company and high remuneration of the manager had been disclosed. So the government had to put pressure on the management to discuss with the trade unions and also to requisite employees, which is in principle illegal. And the other very important strike we had at the beginning of September was a strike of EDF, the nuclear plant, which of course has a very important impact in the context of energy crisis we have to all face in France. Now an agreement was found with the trade unions end of October, but it really had an impact and provided and triggered concern for the governments, given the crisis we're facing at the European level. And
it's quite frightening to see that workers in a nuclear power plant start industrial action, I think. Before I hand over to Richard, I forgot to mention, if you have any questions in between, please use the Q&A function on the bottom of your screen, and if there's any questions, then we will jump in so that it is a little bit more lively. So thanks a lot. Please let us know if you have any questions, then we can directly go into this and answer those questions. Thanks. And Richard. Richard,
yeah, thanks, Alexander. Yeah, so yeah, there's been a kind of a similarly gloomy outlook in the UK since the summer, really, because for the first time in years, kind of touching on what you were saying earlier, there's been really very concerted industrial pressure across basically every sector in the UK. So lots of companies are seeing the first strike action they've had in years, with workers across industries, you know, from mail workers to telecoms engineers, all going on strike over the summer and into the autumn. There's been sustained industrial pressure at the UK's major ports, some of whom are operated by our clients with whom we've been working very closely to help them manage the disruption. There's also been, concerted industrial pressure in the aviation industry in the summer, and lots of clients, with really extensive industrial relations experience are kind of reporting to us what they see as a real ramp up of union pressure in the face of the cost of living crisis.
Mm-hmm.
And as we're coming into the winter now, things just aren't getting any better. Inflation in the UK is continuing to be high. There are Christmas strikes impacting not just transport, which, similar to France, I think is historically quite common here, but also workers in education, in healthcare, mail delivery and private security all going on strike in the next few weeks. Mm-hmm. I think Christmas is often a target for industrial action because obviously there's a lot of additional disruption that industrial action has during that period specifically. But there's no real sense, certainly not from the clients I've been speaking to, that the industrial landscape is going to be any calmer as we move into 2023. And as we're kind of in the run up to the end of the year, we've got major industrial action taking place basically on every single day in December. So a really rather gloomy outlook in the UK at the moment. Mikhail, do you want to take us into some of the detail now? Oh, sorry,
I think it's Jose. Sorry, Jose.
Yeah,
if you could
hi,
take
hi everyone, and thanks for joining. As you see in this heat map, we have marked in red both France, Italy, and the UK as the countries with lower limitations in order to call for industrial action. So you see, and you will see that both in Spain and Germany, there may be situations in which collective bargaining may limit the ability or the right to call and use the right of industrial action. If we go to the next slide. Yep. With regard to the grounds for calling and using industrial action, both from unions or employee representatives, first of all, we need to know that many times the grounds argued by the employee representatives are not the real ones behind the dispute. So sometimes they are used in order to cover or as a tool for collective negotiation or collective bargaining, and also to booster those situations in which the unions are negotiating. In all countries, regulations are broad. As soon as you may connect the dispute to any situation related to wages increase, employment conditions, or freedom of association, it is very easy to connect the right to call for industrial action. In each of the countries, the regulations are different and specific. For example, in the UK, they connect a trade dispute for the right or to the right to call for industrial action. In Poland, they call collective conflict. In Netherlands, just conflict, and in France, a professional claim. So we need to take into consideration that it is very easy to put on the table a ground, a real or legal ground, to call for industrial action. Those regulations in each of the countries go further. For example, in Italy, Poland, the Netherlands, and Spain, it is expressly forbidden political strikes. It is probably difficult to define what is a political strike in any of the situations, and sometimes it is difficult to connect or to evidence what is a political strike, and in order to act or to apply this prohibition. Also, with regard to solidarity strikes, those are expressly permitted in France and Italy, and expressly forbidden in Spain. So, as you see, there are different scenarios around the region we are covering. And a very interesting element to end up this slide is that both in Germany and in Spain, collective bargaining agreements, CBAs, can limit industrial action during the term of and its duration. So during if you have a CBA in place, those CBAs can limit the right of using industrial actions to, let's say, to defend the conditions included in that CBA. So it is a very, very interesting scenario just to control any situation that may arise. So let me pass on to my colleague Max, who will deal and explain what types of lawful industrial action exists.
Thank you very much, Jose, and very happy to be with you all today. The heat map on the screen is slightly different from the previous one. It shows a more consistent approach towards the methodology of union of industrial action, where in the majority of the countries in our survey today, striking is the fundamental form of it. Only Italy and the UK single out as, and we will see it in more details in a minute, as more, let me say, creative ways of industrial action are more common. This is not surprising in a way, because as you well know, striking is a constitutional right, and in most of the countries an unrestrained constitutional right all across continental Europe. Only the UK are out of this, and I understood before from my colleague Richard that actually you can terminate an employee on strike for a continuous period of time and exceeding a certain limit. So this is probably making a big difference across the region. If we could move to the next slide, I will go into a little more details of the case studies that we have collected across the region, where you will see that, of course, in all jurisdictions, a strike, as we said, is lawful, but there are restrictions in relation to different forms of union action. The case study includes typically the work to rule or go slow practice, which is typical in the Netherlands, and where employees basically follow instructions in a bureaucratic and overtly strict manner, thus delaying the entire workflow. You also have a refusal to work overtime, which is typical in the UK, as I understand. And the checkered strike is a very sophisticated organization of union action, typical in Italy, where basically employees strike in shifts that are specifically sequenced in a way to disrupt the entire production line, or is a strike limited to certain functions such as quality control or IT or logistics, which would severely hamper the production output. Picketing, as Alexander was also mentioning before, outside of the plant, is also pretty widespread practice across Italy and sometimes in other countries, and this may of course include blocking or not the entrance to the plant and to the warehouse. In France, Germany, Poland, and Spain, almost all industrial action will consist of a strike action. Temporary abstention from work, literally speaking. In Italy, the Netherlands, and the UK, as we said, we have a wider range of industrial action. In the UK, the refusal to work overtime and work to rule are very common, but it is not lawful to prevent goods or services from being supplied other than through a temporary abstention from work, which basically means you cannot block the entrance to the plant or the warehouse. In Italy, it is instead pretty common, particularly over the past couple of years, and we have handled some significant strike cases that hit all national media, because airports and highways were blocked by the demonstrators. This is generally regarded as lawful when the strike is simply aimed at persuading other employees of external providers. It could be the transportation or the logistic provider, to join the strike, and so abstain themselves from working. This is perfectly legal. You may call it a sort of a call for solidarity. While on the contrary, picketing outside the premises of the plant or warehouse, which is physically obstructing the entrance and the exit of the goods, is generally regarded as unlawful. This is sometimes, and the chronicles report several examples of criminal behaviors associated with this type of hardball picketing, I would say. And this usually justifies the intervention of the police. And that's exactly the case that I was alluding to, where the employees on a strike were actually blocking the road to the airport in Naples, which was, of course, causing a major disruption in the entire transportation system of the area. This is the case where the police would usually take control of the situation, but anything other than that is usually regarded as a lawful way of demonstrating and acting in this respect. Thank you very much, and I'm passing over to my next colleague.
Yes,
Yes,
so,
Eleanor.
Eleanor again.
yes. So now this heat map addresses the procedural requirements before implementing an industrial action across Europe. And as you can see, there are big differences between the countries in that respect. So when the countries are red, i.e. France and Italy, it is very difficult for employers to prevent from strike to take place, because there are definitely no procedural requirements for the trade unions or the employees before to initiate said strike. On the other hand, when you look at Spain, UK, and Poland, what you can see is that there are specific requirements that must be complied with by the trade union or the employees calling for an industrial action. And those procedural requirements, of course, would help the employer to try to prevent the strike to take place. We have some kind of intermediate countries, which are Germany and Netherlands, where there are procedural requirements, they exist, but those requirements are rather flexible. So maybe we can elaborate a bit more and go to the next slide. So in France, as I mentioned, and the same in Italy, there is no procedural requirement, meaning that the employers, the employees, the strikers, just have to inform the employer in advance that a strike will take place and inform the employer of the claims. But there is no formalism with that information, and there is no notice requirement in that respect, meaning that it can be just 1 hour before the strike takes place, to the extent it complies with the legal the requirements for a strike to be lawful. Then the employer has no way to prevent the strike from taking place. It's different in Germany, where a ballot should be implemented within the trade union, and a notice should be provided to the employer. It being understood that there is no specific time frame for that notice, and that although the ballot has not been duly implemented, it cannot be used to consider that the strike is unlawful just because of that. It's more or less the same for the Netherlands, where a notice is required, but there is no specific time frame as well for that notice. The only thing is that it can be used by the employer. The fact that the notice was very short can be used by the employer to challenge the validity of the strike. So the strike could be considered invalid, unlawful, based notably on the fact that the notice was too short. So these are requirements, procedural requirements, but rather flexible. It's very different in other countries such as the UK, where a ballot is definitely required and a 14-day period must be complied with between the notification of the strike to the employer and the starting of the industrial action. When it comes to balance, the trade union must initiate a collective dispute, which is a summary of the claims and of the grounds for the strike, which the employer is not in line with, and then 2 specific timeframes have to be complied with. It's not possible to launch the industrial action, to start the industrial action earlier than 14 days after the collective dispute has been provided to the employer. And it's not possible to start a strike, an industrial action earlier than 5 days before the employer has been notified of the strike. So very restrictive time frame.
Mm-hmm.
But the most restrictive country remains Spain, where the trade unions must inform the employer within a specific time frame, 5 days, inform also the authorities, and where a specific mediation must take place before implementing the strike. So maybe Jose can complete a bit.
Yeah, thank you, Eleanor. Yeah, indeed, there are 3 levels of requirements here in Spain. As you mentioned, you need to inform both labor authorities and the employer, also provide a notice that must be at least 5 calendar days for regular activities, and will be no less than 10 days if the services involved are the so-called essential or public services. And the last element, which is very important, is that you need to follow a mediation procedure within such notice period. And in most times, both the unions and the companies uses that mediation as another strategy scenario in the dispute at hand. So you need to assume that many times there is a call for the strike, but at the end there is not an effective strike, because the parties use those mediations to go forward their petitions or the situations and negotiations. So it is very interesting to analyze that situation if any of you need or have a dispute in this regard.
Mm-hmm. Thank you, Jose Prieto and Eleanor. That's interesting and very, very different throughout Europe. Interesting to hear. Whereas in France, you can be caught by strike activities within an hour, whereas in Spain it takes very, very long, and you have time to mediate and to maybe come to a settlement or to compromise. So let's carry on with Michal to tell us about injunctions, whether this is a measure to stop strike activities. Michal, please.
Thank you very much, Alexander. Hello, everyone. We are now going to look at ways in which the company can actually deal with a prospect of industrial action. So we will discuss issues like ensuring operations, what can be done with the employees taking part in the industrial action, or even potentially suing trade union for damages for unlawful strike. However, one of the most immediate questions you may face is, can you actually stop the industrial action from happening in the first place? Typically, it could be done by obtaining injunction from a local court on the basis that this industrial action was unlawful. As a result, the court could order that this strike is unlawful and can prevent it from taking place. Looking at this question from the Europe-wide perspective, it is theoretically possible to obtain such an injunction in all the jurisdictions we are talking about today. However, as you can see from the heat map, in practice, an option to get an effective injunction varies greatly between the countries. In some countries, it is really an effective and commonly used measure. However, in other countries, although it is theoretically possible, it would be highly unlikely in practice. Let's move on to the next slide for details. So I will mention France first. So in theory, it is possible to get an injunction. However, as discussed earlier, given the complete lack of procedural requirements for industrial action, it will be highly unlikely in practice. So as Eleanor explained a while ago, there is no notice requirement in France and actually no procedural requirements other than just informing the employer. Therefore, in most cases, the company would be unable to prove that industrial action is unlawful, and therefore it would be rather unlikely to get an injunction. In other countries, such injunctions could be an effective measure to consider. So, for example, in Italy, it is only possible to obtain an injunction if there is a blockage of goods or an occupation of the premises. So we see strict limitations in this respect. In Germany, on the other hand, the practical ability to get an injunction is also limited. It would only work if the strike is manifestly unlawful and legal protection is necessary to prevent substantial disadvantages for the company. In Spain, Poland, and the UK, injunctions are normally limited to situations where the procedural requirements of the industrial action have not been met. As you could see from the earlier slide, the UK was marked as green on the heat map, but it isn't because it is very easy to get an injunction there. Unlike in France, there are many procedural requirements for going on strike in the UK, and the procedures are detailed. So the trade unions would have to follow a lot of formalities to get it right. And if there are some errors in this procedure, there is a potential for the company to obtain an injunction. And there are a lot of examples and case law showing that employers were actually successful in obtaining some such injunctions and preventing the strike actions. Baker McKenzie has worked on such cases successfully. Mm-hmm. So now, from a practical perspective, in most of the countries discussed today, the company will be able to stop the industrial action from taking place if they spot some errors on the part of the trade union. Mm-hmm. However, there's one tactical point I would like to raise here, and the issue that should be considered. Once the company actually spots that the union has made this error in one of the procedural requirements, there would be a question of whether to flag this immediately to the union or maybe immediately go to the court for an injunction. Because sometimes it may be a good strategy not to raise this issue until it is too late for the union to correct this mistake. Then, just before the strike action, it could be potentially possible for the company to go to the court, get the injunction based on these errors, and then prevent the strike action from taking place.
Thank you, Michal. This is very helpful and insightful, in particular with this strategic advice when to raise issues on the side of the union and using this in a temporary injunction to be obtained from the labor courts. Now, turning a little bit now further to contingency planning? What options do we have as a business if we are facing industrial action? And we have looked at the agenda. We have 3 different topics we want to run through. And the first topic is options to keep the business running. Richard, please.
Thanks, Alexander. So if you're not able to stop the industrial action, then obviously contingency planning becomes very important. And kind of an obvious way to start thinking about doing that is by, bringing in other people to cover the work of the striking workers. That's either from other people from within the business or sourcing labour from third parties. But as you can see from the heat map, the extent to which you're going to be able to do that is going to potentially vary quite significantly between the jurisdictions. From there being a lot of scope to do it in the UK, it's a bit of a running theme, very little in Spain. And then in between that, like literally in between that, there's kind of a range of similar but different options in the amber countries, which I'm going to come on to in a moment. But moving into the detail then on the next slide, and starting first with the only green jurisdiction, which is the UK. So the UK has been the government in the UK has been particularly keen recently, against the backdrop of the industrial unrest that I mentioned earlier on, to kind of loosen up on restrictions on employers during strike periods. And one of the measures they've introduced is a relaxation of what until have been relatively recently some fairly restrictive prohibitions on bringing in strike cover. So up until July this year, it had actually been a criminal offence for employers to use either employees of other group companies or from third-party temp agencies to cover striking workers. Although genuine outsourcing arrangements had always been permitted, but in practice were quite difficult to implement for such short-term durations. But that restriction is gone now, and employers effectively have a completely free hand to source alternative labour during strike periods. Now, initially, there was kind of a political suggestion that the employment agencies themselves, kind of out of solidarity, would refuse to provide temporary workers just to cover strikes. But actually, anecdotally, that's not been the case based on what we've seen, and we've acted for, we have acted for employers who've managed to source temporary strike cover from agencies during this period. Kind of turning to the amber jurisdictions, and as I mentioned, there's kind of several variations on similar themes. In France, whilst the employer's not permitted to use temps or fixed-term employees to cover, similar to the UK, they can, or similar to the older position in the UK, they can again use genuine subcontracting arrangements, as well as bringing in other employees from within the same company to provide cover. And that's kind of similar in Italy too, where other employees can be used as well, so long as they're not kind of being demoted, even temporarily, by being moved into that cover role. But again, in Italy, there is a prohibition on using temps or fixed term or on-call workers to kind of cover strikers. Now, it's not possible to use temps in either the Netherlands or Poland, but in practice in the Netherlands, lots of employers also use this kind of subcontracting method as a way to work around the prohibition. And so whilst that's not, whilst that's arguably not in keeping with the spirit of the law and so potentially vulnerable to challenge, it is a relatively common practice. In Poland, employers are actually, that's not the case in Poland, where employers are limited to using workers from within the business to cover those on strike. And that's much more similar to the position we just saw in Italy. Wrapping up the amber countries, the position is most generous in Germany, where the employer can use third parties, subject to the temporary workers, these agency workers, having a statutory right to refuse to provide that cover. And as we've seen kind of, I think, a few times now, in Spain, which is the only red jurisdiction, it's the most restrictive. In Spain, employers aren't permitted to use strike cover at all, so they can't redeploy internal resources or source external resources unless, or save in cases where that's actually required to cover security and maintenance services. So speaking of Spain, I'm going to hand back to Jose now to talk us through demonstrations and picketing.
Yeah, thank you, Richard. Yeah, if we go to the next slide, please.
Sorry, maybe in the meantime, there was a question in the Q&A section. One Max is taking care of, but the other one was about temporary injunction. How long does it take? And maybe we can reflect on that a minute. Michal and maybe someone else who wants to chime in. if there is a temporary injunction, or you think about going for a temporary injunction with the labor court, it's of course of essence. How long does it take to get one?
Great. Thank you so much for this question. So naturally, the idea of this temporary protection is that it should be quite quick, because the employer will have to act quickly. There's a threat of important disadvantages. However, it doesn't work that way in all the jurisdictions that we're talking about today. So, for example, it would be getting such injunction in practice would be a matter of days in the Netherlands, in France, and probably in Poland. However, in Spain, it could be weeks or even months. So it varies greatly between the countries.
Thank you. And also in Germany, it's a couple of days or a week maybe, but not more. Spain is really sticking out in this respect. Okay, then can we carry on with contingency planning too? And, you know, options to deal with picketing and demonstrations.
Thank you, Alex. As you see here, again, Spain is marked in red. We have plenty of restrictions here that are very interesting. For example, well, getting back to the most of the countries, dealing with picketing and demonstrations, you need to know that picketing and demonstrations are broadly permitted in general in all countries under scope. And all countries protect similar situations or rights. For example, those rights of non-strikers employees to go to work. All countries protect and limits any acts of violence or and mention safety as an element to protect for employers. Some of the jurisdictions include express references to company production in order to be protected. But here again, in Spain, there is a real difficulty to avoid or control picketing and demonstrations. And in general, you may see that companies' entrances are sometimes blocked with difficulty to transport or to receive and to transfer goods to the customers. So here it is very, very important to anticipate and to plan and to produce a contingency plan in order to, let's say, create a stockage necessary to serve your clients accurately. We have been through very, very sensitive cases here, and one to mention could be one in which we advise a client when it decided to hire security guards with chest cams in order to control what was happening in the entrance of the factory, because there were sensitive situations affecting the safety of the workers that wanted to enter into the facility. So here you see again that that there are different situations. There are countries in which it is easy to call the police, and the police will act immediately in order to control those potential acts of violence. Here in Spain, the police and the authorities sometimes will look at the situation very restrictive. Obviously, if there is an act of violence, they will act. But in those gray areas in which the employees are strongly, let's say, picketing, even as I mentioned, blocking the entrance of the company, the police will not act immediately, and you need to anticipate that to create a good plan for that situation. So it is again a different scenario across the regions.
Mm-hmm.
If we go to the next slide, you will see that those details. And as I mentioned, in Germany and Italy, it is possible to inform directly the police or the state prosecutor, and you will receive immediate help from them. And as my colleagues mentioned, you can use injunctions in order to stop or to control any potential harmful scenario that may arise. But again, both in all regions, it is important to anticipate and create a strategy in order to have a lean production in order to serve your clients and your customers.
Mm-hmm. Hey, thanks a lot. We do have another questions. There's a question that came in about what employee population are works councils crucial, and how can companies get ahead of that, and also on CBAs. Now, this refers, I think, rather to Germany, where we have employee representation in works councils. And the question here is, works councils, they can be set up as soon as there's 5 employees, they can elect a works council. But the works councils legally have to stay neutral during strike activities, which are organized by the unions. That means that they are neutral in terms of what they do. They cannot actively support strike activities as a works council, but the members of the works council, they can be, and they sometimes are, union members. And as union members, of course, they can support a strike, but they are not allowed to use the means of the works council to support a strike. That's sometimes difficult to differentiate, but that's what the law says. And they don't have to be neutral individually, but they have to be neutral as a representative body of the employees. I think that's important to note here. Let's carry on to the next one. And that's about contingency planning. 3, sanctions for employees. Now, can you sanction employees because they take part in strike activities? And here the answer is also different. If you look at the heat map again, so it's possible to make any additional payments, but you can't dismiss employees. I think that's the general feature, because as Max mentioned earlier, it is a constitutional right to go on strike, at least in continental Europe, and therefore any immediate detriment or disadvantages the employees are exposed to, that is not in line with the Constitution. Is it possible to make any additional payments, but to not to dismiss employees, but to put other disadvantages to those employees? This is possible in the UK, and that all sanctions are possible. This is, well, nowhere really, and that would be again surprising. So let's look at the further details on the next slide. In all jurisdictions, as we said, it's unlawful to dismiss somebody for taking part in industrial action. So this is unlawful, with the exception of the UK. And maybe I can ask Richard here to chime in that it is possible to dismiss employees under certain circumstances. Maybe you can tell us in a few words what's the latest legislation here.
Yeah, so it's relatively complex, but broadly speaking, if the industrial action continues for a period of at least 12 weeks, and the employee continues to participate in the industrial action after the 12-week period is expired, then they can, in theory, be lawfully dismissed, provided that the employer dismisses not just that one employee, but every employee who continues to participate in the industrial action. That's in relation to industrial action which has the support of a ballot and the procedural requirements that Eleanor mentioned have been complied with. If the industrial action is what's known as unofficial industrial action, so it doesn't have the support of a ballot, the procedural requirements haven't been complied with, then it is lawful to dismiss employees in those circumstances.
Mm-hmm. Thank you, Richard. Now, it is permitted in all jurisdictions to remove salaries and certain benefits for the period of industrial action. Basically, when employees take part in strike activities, as an employer, you don't have to pay them for that. And usually they get some sort of compensation from the from the union. In Germany, we say it's the best kept secret how much money the unions have to provide for that compensation. And it is not a secret that unions in Germany, at least, are very rich. They invest money, they act like investors because they have a lot of money, and they well, sometimes need it to pay for that compensation. Now, from an employer's perspective, you save money, but you want to continue with your production, with delivering services. You can pay premiums to employees who do not go on strike. So that is possible in Germany and in the UK. In other countries, that's difficult to pay anything on top, but this is what you can do. And as Richard mentioned already, it is possible in the UK also under certain circumstance to dismiss employees, but you can remove employees from discretionary benefits permanently, even if they participated in industrial action. So that's also different to continental Europe, where once the strike is over, the employees get their salaries, get their benefits, and even in terms of discretionary benefits, you could probably not say, well, we are not paying this discretionary bonus because someone took part in industrial action. This would probably different. You need to find other reasons simply than this one. See, there is another question. Yeah, there's another question where an employer offers financial incentive to individual workers who do not on strike. Is there any limit or other restriction on that? That's a very good question, because in Germany, for example, you cannot pay a very high amount. It has to be reasonable. Of course, what is reasonable under those circumstances? You could probably pay, if you look at the day's pay, pay a premium which is 30, 40, 50%, but doubling the pay is probably different or difficult. And the risk, if you don't do it right, is that others, in particular those who go on strike, could claim the premium as well. So maybe others out of this group want to comment on that. Is there a limit where those premiums can be paid to employees? Richard.
Yeah, so in the UK, the answer is theoretically no, but in practice, yes. So the law in the UK prevents you from punishing somebody from taking part in trade union activities, and it also prevents you from paying them not to take part in trade union activities. But at the moment, the court has held that industrial action is not a trade union activity. So that ruling is being challenged to the Supreme Court, and if the Supreme Court overturns the decision of the Court of Appeal, that would mean that it wouldn't be possible to pay premiums at all, and it wouldn't be possible to punish somebody for going on strike at all. But at the moment, it is lawful. So there's an element of risk there, because any judgment is going to have retrospective effect, in the sense that if you do something now, the Supreme Court later says, well, the law wasn't what we thought it was before, you can still be sued for that. So what employers would tend to do, the way it would tend to be framed, is rather than saying before a strike, I'm going to offer you an extra 50% to come to work. In the UK, you often have intermittent strike action. So you might have 4 days in this week and 4 days in the next week. What you would do is anybody who came to work during the first strike, you would pay them a thank you bonus for coming to work. So in the UK, you tend to try and position these things as strategically as a thank you for coming to work, rather than as a punishment for not working, or as an inducement not to take part in the action, just to try and hedge yourself against the potential for the Supreme Court to change the law in the next few months.
Okay, thank you, Richard. That's very good to know. And now, finally, let's move to the next slide. So the question is, apart from what we discussed, are there any other effective remedies against unions who call and implement unlawful industrial action? And then Lotte, can I hand over to you?
Yeah, thank you, Alexander. Well, as you'll see, the heat map actually provides a very uniform picture. which means that all of the jurisdictions that we're discussing here today actually do provide remedies against unions that call and implement unlawful action, albeit on limited grounds. And then moving on to the next slide, so we can go into some more detail. Actually, in all jurisdictions, claims for damages are available. In France, however, there's limited practical value in trying to obtain remedies from unions calling for a strike. And the reason for this is that, as we've discussed in France, a lawful reason to call strike action is if there's a professional claim, which definition actually knows a broad scope. And also there are little to no procedural requirements. However, if it is determined after the strike has taken place that the strike was unlawful in the way that it was performed, so for instance, because it was a slowdown of the activity rather than a full work stoppage, it is possible to request damages. And then onto the UK, where a specific cap applies. Damages in case of unlawful industrial action are capped at £1 million. And in order to claim such damages, the company must sue the union for a breach of tort, which will consist of inducing employees to breach their contracts of employment. And in Italy, employers can apply to the state prosecutor to determine whether the workers have committed a criminal offense. And also employers will have the possibility of claiming before a civil court the payment by both trade unions and individual workers of economic damages caused during industrial actions. And in the Netherlands, well, damages incurred as a result of lawful collective action must be tolerated. But if there's unlawful action, employers can seek damages from the organizers of the action. And in addition, if an action would continue without an injunction, the employer can seek compensation for each day that the action continues. And maybe, Alexander, you wish to weigh in from a German perspective?
Yeah, in Germany, there was a ruling a couple of years ago by the Federal Labor Court, which says, yes, unions are exposed to damages if they call for industrial action which is unlawful. So before going on strike, we know that unions very carefully check whether there is a risk for damages, and they do only call for industrial action now until if this has been checked basically by the union's legal department. And so there is some routine in checking this before calling for strike activities. So that has helped companies a little bit because unions have become a little bit more prudent because of that. Is there any additional question from the audience? Because we are now through with our program. We hope that has been helpful for you when you're asked by managers, by your business people, what about industrial action? Is there any risk for us, and what do we do? So you will be able to look at the slides. And if there's any question in particular, if you need some strategic advice, because that's what it is about. If you know the law, this is good, but not enough. What you need is advice by experienced practitioners, which we are. And so we hope that has helped you. And in case there is any question, if you think there is industrial action coming along, unions threaten you, then give us a shout, and let's enter into discussion about what we can do and how we can best help you under those circumstances. So thanks a lot, and have a good day. Bye-bye.
Have a good day.
Bye-bye.
Bye-bye.